What does the Constitution say about how schools should navigate situations where students and their parents disagree about a student's gender identity? How can schools promote the interests of LGBTQ students while also respecting parental rights? Which will it be, Jamie? Do you want it the rock or the hard place?
I would prefer not to be stuck, period. Which is why we're doing this podcast, right? To help educators unstick themselves as much as possible. But today's case is a pretty tricky one, and one that illustrates a constantly changing and hotly debated legal landscape. The balance of parental rights and what schools may think is in the best interests of the student. Trying to balance these complex issues often puts schools between a rock and a hard place. Today, we're diving into Littlejohn versus School Board of Leon County, a case involving a parental challenge to the school creating a support plan for their, quote, gender-confused student. That was how the parents described it. So we are coming to you with another live show today. We are here at the annual convention of the University Council for Educational Administration in Los Angeles. This is exciting. I am really starting to like doing these live shows.
Me too. Yeah, it's kind of fun to actually be able to record in the same room.
I know.
And being in LA is pretty nice too.
It definitely is, although I feel like I've been stuck in this hotel for 2 days. But a lot of great presentations, a lot of good stuff here at UCA. We're very happy and honored to be here.
Yeah, I'm wearing my Lakers socks that I got at the basketball game the other day.
That's right. All right, well, let's get into it.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. Now we're both professors of educational leadership working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Okay, Chris, have you got a bell ringer for us today?
I do. I've got an update for us on one of the curricular gag orders that we've been following. So we've talked about these issues before, but this is an update about an Iowa law. It's Senate Bill 496. And the law requires that schools remove sexually explicit materials from their school libraries. It also forbids schools from providing programs, promotion, and instruction to students in grades K through 6 on topics related to gender identity and sexual orientation. So this is one of those laws, and we've talked about similar laws before. So this is similar to a lot of laws that were passed starting in like 2022. So Florida has the Don't Say Gay law that we're all probably familiar with. And though, as you might have noticed, the text of the law, and actually none of these laws actually say gay.
So they're doing what they said they're going to do. They don't say gay.
Right. Yeah. The law. No, well, yes, I guess so.
I gotcha.
Okay. So yeah. So like the laws forbid instruction on gender identity and sexual orientation, which would apply equally, right? Like, it's going to equally forbid, at least if you just look at the text of the laws, Romeo and Juliet as it would in Tango Makes Three.
Theoretically,
right?
Yeah.
If you just look at the text of the laws, obviously that's not how these laws have been promoted, have they been communicated, have they been packaged, right?
Right.
And, the state of Florida in settling the lawsuit, one of the lawsuits challenging Don't Say Gay, actually came out and said, like, this law applies equally, regardless of sexual orientation or gender identity. And so, the context here, there's been a lot of litigation around these laws,
Right.
a lot of legal challenges
Right.
based on the First Amendment free speech, vagueness doctrine, overbreadth doctrine, or the 14th Amendment, lots and lots of legal challenges to these laws. And so for Iowa's law, the update today is there was an Eighth Circuit Court of Appeals opinion that actually lifted an injunction that the lower court implemented to stop the enforcement of this law. So that means the law can go into effect. And this came about after a group of students, nonprofits, and publishers actually sued to stop enforcement of the law. And so the Eighth Circuit lifted the lower court's injunction. And so, that means the law can go forward, but that it doesn't stop the lawsuits. The lawsuit's still going on. It's just now the law can go into effect.
Right. Okay.
Yeah. And so this is probably not the best result that the students and teachers wanted out of this whole thing, but there are a few things that I found really interesting about the Eighth Circuit's opinion. The first is the court rejected the state of Iowa's argument that the selection of library books is governmental speech.
Really?
Yeah. And that was an argument that we've seen a lot of states make about these laws. They're basically saying like, look, this doesn't affect the speech rights of students or anybody else because it's our speech. It's our speech as the government.
Yeah.
And the First Amendment doesn't have a lot of restrictions on how the government can speak for itself.
Right.
And so if we view this as government speech, then the First Amendment wouldn't really put a lot of guardrails up. And courts have been very, very reluctant to embrace that argument. And even here, and this opinion was actually written by a judge who was appointed by a Republican president. And so even here, they're kind of moving away from that argument because hopefully because of the profound implications that would have.
Sure. Okay.
Yeah. And another thing that I found really interesting is the court doesn't explicitly say that the lower court got it wrong in granting the injunction. They say they applied the wrong standard, which means there's a potential here. If they go back and apply the right standard, maybe this injunction comes back.
Wow.
Though there is some interesting language in the Eighth Circuit's opinion that makes me question that, because they've got this quote here that I thought was really concerning. They said, quote, "Given the pedagogical mission and the policy-making authority possessed by Iowa, it is important to bear in mind that Iowa is not required to tolerate speech that undermines or is inconsistent with its central mission of educating Iowa children."
Really?
I don't think that's a good summary of the law, because schools have to tolerate speech they don't agree with all the time, right?
Yeah, exactly.
That was one of the main takeaways of our Bong Hits for Jesus case.
Right.
Like courts had kind of interpreted these cases like Bethel versus Frazier to be too broad to allow schools to censor too much speech.
Right.
So they have to accept speech they don't like, unless it causes substantial disruption or falls into some other category. So I read that line and I was like, that troubles me.
Yeah. This opinion is a little, I don't know.
It's a bit of a mixed bag, right?
Yeah.
They lifted the injunction, but there's still some room to it wasn't a total loss for the plaintiffs.
Yeah. Well, that's interesting. Well, it's another one of these that we're going to have to keep following.
Yeah, we will keep an eye on them because the cases are finally starting to work their way through the system, challenging these laws.
Yeah. And there's a lot of this stuff working through the system right now.
There is, yeah.
And we're going to keep you posted about this one and all of them, or most of them.
Maybe not all of them.
Not all, because there's a lot.
There's a lot.
Yeah. Well, why don't we dig into today's big case? All right. This is the Littlejohn case. Mm-hmm. You ready?
Yeah. See, I'm going to come up with a Robin Hood pun really quickly. Couple.
Not quick enough.
No,
Chris.
no, apparently. See, this is why we don't do this live.
Yeah, all that'll probably be edited out. All right. So as we said at the top of the episode, at the heart of this case is the messy legal intersection of parental rights, student rights, and the school's responsibility to ensure a safe and supportive environment for all students. As we've seen all too often, especially within the last decade or so, who is responsible for what and what it means to be supportive is not necessarily always agreed upon. But like many of these complicated issues, we hope that these kinds of legal cases will not only illustrate the nuance and challenges, but also provide all of us with some important things to think about when we're inevitably confronting these complex issues. All right, so let's talk a little bit about Littlejohn versus Leon. All right. Now, we don't really have all of the facts for this story. Do we ever?
No, we don't.
Yeah, because we're going by what the courts have written in their opinions about what happened, okay? And that often leaves a little bit to the imagination. In this case, the information we have is from the parents' amended complaint, which, because of when and how this case was decided, the court has to accept as true. In other words, because the school district asked the court to toss this thing out, the rules say that the court has to go by the parents' version of what happens, and the school has to agree with that. Mm-hmm. Okay?
Yeah, they don't have a chance to necessarily tell their side of the story at this point.
Right, but they're saying basically, we think we win, or we will win as a matter of law, so we just want, it doesn't matter what the facts are, because we'll win.
Even based on the parents' version of the facts, yeah.
And even if it's based on the parents' version of the facts. So the way that the law works is the courts say, okay, if you want us to toss this thing out, then you have to accept the parents' version of the story as true. And the school has to say, okay. So that's what we're going on in this case, is the parents' version of events here, which the school has essentially said.
Even based on those,
we
don't
still
pass
win.
go, don't collect $200.
Right. Okay. So, according to the complaint, the plaintiffs, who are the parents of a minor named AG, because they're a minor, we don't know the name.
And we never get their real names.
Right. So it's just initials. So AG. And AG was enrolled at Deer Lake Middle School in the Leon County School District, which is in Tallahassee, Florida. So that's right in the northern edge of Florida, in the Panhandle. We don't know much about AG, but what we do know is that they were in middle school, they had been diagnosed with ADHD and had a 504 plan. And most importantly, at the beginning of the 2020-2021 school year, they experienced, quote, gender confusion. That's the parents' words, okay? They asked their parents for permission to use J as a name and they, them pronouns. The parents, for their part, did not give AG permission to do so.
And it's important to recognize here at this point that the court record all uses AG to refer to the student.
Yes, correct. So the parents decided to express those desires or those feelings to the school. So AG's mom emailed AG's homeroom teacher to tell her that AG was expressing gender confusion, that they were seeking a private counselor for AG, and that the plaintiffs, the parents, did not consent to AG using J as a name, or they, them pronouns. But AG could use J as a nickname with teachers and classmates. Now, what I'm kind of reading into that is that the parents didn't want this to be a formal change, but as a school, I'm looking at this like this is a possible loophole for us, right? They said, they told us we could use J as a nickname.
Right. They just don't want it to be reflected in the official records and things like that. Yeah. So it's kind of like a have your cake and eat it too kind of moment where like the parent kind of probably recognizes that they can't control what happens in school potentially, right?
Possibly.
We'll talk about that.
We're reading into this, right? Yeah. So sometime later, AG approached one of the school's counselors, all right, and requested to use a different name and pronoun at school. Now, we have no idea if the homeroom teacher relayed any of the parents' concerns to anybody else at the school. It doesn't say in the court record. So we have no idea if the counselor knew that the parents didn't want AG to go by a different name and pronouns at that time that AG requested the meeting with the counselor. So the school counselor sets up a meeting to discuss the request and create a support plan for AG. At the meeting, which took place in September of 2020, AG, the school counselor, and several other school staff, we have no idea who, it just says in the court report or in the court opinion, several other school staff. We have no idea if the homeroom teacher was a part of that. Those were the people in the meeting, and they met to develop a support plan which allowed AG to choose their name, pronouns, restroom, and room sharing arrangements on school field trips, which, as a former school administrator, that's, that's a tough one. That last one, the choosing rooms on a field trip, we're not seeing very many policies about that out there right now, because I think most schools and districts or whatever are just really scared to dive into those waters.
Right.
So it was very interesting to me that was a part of the support plan.
Mm-hmm. Yeah. And this raises there's so many complicated practical challenges here,
Totally.
right? Not even just kind of recognizing the different interests and the different kind of stakeholders at play in these decisions too, right? And so the support plan, one thing that I find really interesting about this story is that the support plan with all of those things was kind of developed pursuant to a district policy that they had adopted, which was their 2018 LGBTQ support guide.
Yeah.
And so there was this district document that they were following, which, kind of goes to these proactive policies. So in the sense, and this is in Florida in 2018 and 2020, obviously the political landscape and there's new laws about this stuff in Florida now. But it's nice to see the district kind of being proactive to address those practical challenges that now, okay, we've got a policy. Let's follow our policy.
Yes, right? Exactly. Yeah. So this is where things start to get really interesting. So in accordance with the guide, that policy, AG's parents were not notified of the September meeting or invited to attend because AG did not ask for them to be present. Okay. The support plan that they developed mentions that AG's parents were, quote, aware but not supportive, unquote, of AG's decision, which implies that either the homeroom teacher or AG communicated this to somebody, because it did appear in the support plan.
Right.
But according to the parents, nobody at the school ever asked AG about whether they wanted their parents to participate or not.
Right. Yeah.
Again, that's according to the parents.
Yeah. Because I think the policy said, we're only going to involve parents at the child's request.
Right.
Yeah.
But we don't know if they said, hey, do you want your
if there was
parents?
a notification.
Right. Yeah. So about a week after the September meeting, AG told their parents that they met with the school about their restroom preferences. I have no idea if they mentioned to their parents about any of the other things that were in the support plan. All that the court opinion says is that they told their parents that they met with the school about the restroom preference.
Yeah. The parents found out about somehow.
Because mom immediately contacted the counselor and the school's assistant principal asking about that meeting. We have no idea how that contact was made, whether it was through email or did she walk into school? We have no idea what the tone of that, if that was sort of a productive kind of collegial sort of
fact-finding mission,
or if she was sort of a little more aggressive. We have no idea. We just know that mom contacted the counselor and the AP. All right. At that point, the school declined to provide the mom with any information about the meeting. And that was sort of in accordance with
seemed to be part of the policy.
Policy, right? According to the school, AG was protected under non-discrimination law, and that law did not provide for parental notification or input. All right. So it was the school's position that by law, AG was the one who had to request that their parents attend. All right. So after some back and forth with all of this, mom receives a copy of AG's support plan and more information about the meeting. She also refused permission to allow the school to meet with AG alone about these topics moving forward. All right. Because apparently there had been another meeting on the books.
Yeah, it was scheduled and we're not sure, again, it's unclear about whether it went on, but the parent is very much putting her foot down here.
Yeah. Because there was that meeting on the books between the school leadership and AG to discuss the support plan a little bit more. But they were directed to cancel that meeting by mom. And I'm not really sure if the district went through with that meeting or not, because at that point, the parents had had enough. And what did they do, Chris?
They do what everyone does if we're covering it in an episode of Chalk and Gavel. They filed a lawsuit.
Oh, I thought you were going to say they all shook hands and gave each other hugs and
that's
went
the
out
end
for
of
dinner.
And that's the end of the episode. Thank you all so much for coming. Yeah. So, I think before we dig into the lawsuit, this fact pattern, like, it just really demonstrates the really hard position this school is in.
Totally.
Right? Between, like, you've got these parents who are expressing very valid concerns about, like, their parental authority, their responsibilities, their obligations towards their child. And then you've also got the school, which is very much following the student's lead here.
And the policy that the district has.
Yeah, right.
Right. And they're, and I'm sure there's a lot of folks in that school who firmly believe that they were doing what would have been in the best interest of the student, right?
Right.
And we said it at the top of the episode. This stuff is not easy. Like, this is complicated and it's messy.
It is. And it's one of those situations where it's an unsettled area of law, right? Which is one of the reasons why we're talking about it. And so you've got legal concerns or, like, valid legal arguments on all sides. And so it's one of those situations where, like, you as a school have to be really, really confident, or at least intentional, about, like, how to navigate this thing. Because in a certain way, you're almost kind of like picking who's going to sue you.
Yeah.
Which is not a good place to be as a school district, but it's kind of where we're at with a lot of these situations until courts kind of grapple with them and we kind of know better what the landscape is like.
Yeah. And don't let this scare you, listeners. You're not necessarily going to get sued by somebody one way or the other.
No.
But that's why we're doing this show.
Because you're listening to the show.
Yeah. So what happened with the lawsuit?
Yeah. So the parents brought this lawsuit in federal court against the school board, against the counselor, against the school leaders, the assistant superintendent, everybody involved with the support plan and the policy.
Which is very normal when these lawsuits come out. Like, anybody who is even remotely connected to the event, we're going to throw them into the lawsuit.
Right. Yeah. But the big thing is against the school board because they're the entity in charge.
Yes, exactly.
So the lawsuit alleged that the school violated the 14th Amendment's due process clause, as well as a couple violations of Florida's state constitution. So we're in federal court because these are federal constitutional claims. The court doesn't really address the Florida state constitutional claims, but it does look at these substantive due process claims. And the short version is that the parents are essentially arguing that cutting them out of the decision-making process on AG's support plan harmed AG. It violated their parental rights to kind of direct the care and upbringing of their child, and it improperly intruded into their family dynamics, all in violation of the due process clause of the 14th Amendment.
Right.
Now, the school obviously disagrees because they don't think they did anything wrong, and they immediately file. Jamie, you ready for this?
Oh, I'm ready.
They filed a Rule 12b-6 motion to dismiss for failure to state a claim. It's your favorite rule of civil procedure, Jamie?
I mean, I like them all, but motion 12b-6 is my favorite.
Mine too, actually.
I had no idea what it was before I started this podcast, so...
Jamie keeps me honest with the legal terms.
Yeah. So, like, a motion of 12b-6 or 12b-6 motion, that's the one that essentially argues that even if you accept everything the other party, the parents in this case, is saying is true, we, the school, still win as a matter of law. Okay. We talked about that a little bit before. So the school here doesn't think that there's enough here to even move past the initial stages of a lawsuit.
Exactly. Right? And spoiler alert, the court agrees with the school.
Oh, really?
Yeah, the school wins this one.
Okay, so why? Why do they agree with the school?
I thought you'd never ask. So the first issue that the court has to deal with is another one of our favorites. They have to deal with this question of qualified immunity.
Oh, we like to talk about qualified immunity on this show.
It comes up a lot, right? Because it deals with the discretion that government actors have.
Right.
And so you're probably more familiar with this qualified immunity doctrine in the policing context, but it essentially protects government officials from liability as long as they are acting within the scope of their discretionary authority, basically as long as they're in the
doing their job. Yeah, basically.
Doing their job,
yeah,
right? Yeah. And their conduct, and this is the important, or I guess the second part of it, but this is usually where the questions come, as long as the conduct does not, quote, violate clearly established rights of which a reasonable person would have known. And so that's kind of the term of art here. And that's kind of what they're fighting about when they're fighting about qualified immunity is, was the parental right here clearly established such that an administrator ought to have known about the rights that these parents are claiming and known that, like, what they were doing was wrong or infringing on those rights.
Yeah. So it's basically, it protects the school official when they're not acting with malice. They're acting sort of, they're doing their job. They're doing the best they can.
Right.
You know, I'm obviously overgeneralizing here, but you know, that's basically what qualified immunity is for.
Right. Where there's gray areas, qualified immunity ensures that folks have the discretion that they need to do their job.
Yeah.
Right. And this is one of those gray areas, right?
Yeah.
Because the court looks at all of this and says, look, there's a reasonable school administrator would not know kind of the exact contours of parental rights because this is a very
unsettled issue.
Yeah,
right.
not a lot of courts have dealt with these issues.
Right.
And so we're starting to see a lot more of these arguments, you know, because we're in the middle of what, you know, I've started to come to think about as like a second parental rights movement in the United States. And so we're starting to see that courts have to grapple with these arguments a lot. But for now, you know, the Supreme Court hasn't really told us what the substance of parental rights to direct the care and upbringing of their child are and how courts should navigate those rights. So because of all of that, the court recognizes that the individual defendants, meaning the teacher, the counselor, the superintendent, all have qualified immunity.
Great.
Yeah, but that's not all, because we still have the lawsuit against the school itself through the school board.
Okay, so we've basically taken the counselor and the administrator out of this lawsuit, but now now all that's left is
they're still involved, but the lawsuit is no longer against them.
Against them.
Yeah,
right.
yeah.
Gotcha.
So the claims against the school board all allege violations of the substantive due process rights protected under the 14th Amendment. So the 14th Amendment's due process clause, that's one of the, you know, when we talk about the 14th Amendment, we're often talking about the due process clause or the equal protection clause, focusing today on the due process clause.
Which is the thing that in schools is often applied to a lot of discipline stuff. It's the reason why, you know, there's a 11 day demarcation between
suspensions of 10 days or more, notice of a hearing,
and what is required in order to do those things, right? Like that's all due process, right?
Exactly. Yeah, because due process protects against deprivations of life, liberty, or property by governmental officials. It makes sure that those don't get taken away without, quote, due process of law.
Exactly.
Right. And there are kind of two flavors of due process. So what you've talked about is the procedural due process.
Yeah.
Exactly.
Yeah.
And that kind of basically just says the procedures the government has to go through before they take life, liberty, or property away from you.
Right.
The more significant the interest, the more procedures they have to give. Substantive due process, though, deals with whether the government's actions are sufficiently justified by their interests. And so it recognizes that there are some things that are just so important that unless the government has a good enough interest, all the procedure in the world isn't going to be enough to justify that deprivation.
Right. So in other words, it doesn't matter if you have all kinds of rules or procedures that are written beautifully and clearly stated in your handbook, whatever, if the rule itself doesn't have a good enough reason for being a rule, it's no good.
Exactly.
Yeah.
Right. Yeah. And this is all part of the due process clause because it's basically ensuring that people are not subjected to arbitrary or unreasonable governmental action, right?
And so that's basically, you know, one of the big takeaways there is don't think as a school administrator that you can put whatever you want in the handbook and just say, but it's in the handbook. You know, that's not always good enough.
Yeah. Yeah. We want to make sure that the government doesn't act arbitrarily or capriciously or unreasonably because, you know, that's something we like to tend to avoid if we can, right?
Exactly.
So there are different standards for determining whether a governmental actor has violated substantive due process. But for these claims, the court looks at whether the school's actions were either, quote, arbitrary or, quote, conscious shocking in the constitutional sense. Perfectly clear, right?
Yeah.
Yeah. So the court gives us a little bit more to go on because that is, you know, a little bit, as I like to say, it's a squishy term.
Squishy term.
Yep. So the court elaborates that only the most egregious official conduct can can be said to be arbitrary in the constitutional sense. So this is an incredibly high bar. It has to be egregious official conduct. And typically what that means in these kinds of claims is that the governmental actor acted with malice or some sort of intent to harm some constitutionally protected interest.
Yeah. So like in this case, it's like they're basically saying that the school's actions were done to intentionally endanger that child, right?
So they're making a couple arguments. So they're basically saying like in our society, it is egregious to allow a school to cut parents out of these decisions. So they're not necessarily that like you did it to harm us. They're saying like, we can't allow this sort of thing to happen because that's an unreasonable thing for the school to do.
Got it.
And that rises all the way up to a level of shocking the conscious within our society.
Okay.
Yeah. So
my conscience was not shocked.
And neither was the courts. Hey, there you go. Look at that. So we've already kind of alluded to this, but this is a very unsettled area of constitutional law. The Constitution doesn't explicitly say anything about parental rights. The Supreme Court has interpreted the Due Process Clause to protect the right to direct the care and upbringing of children. But that's the court interpreting the Due Process Clause. So this is one of those unenumerated rights that's not explicitly spelled out in the Constitution, but that courts have recognized and that they've protected. So like, there's not a lot of guidance here about what these rights mean.
All right. So we've talked about it, but they haven't really given us very much to go on, right?
Right. Yeah.
Thanks a lot.
Thanks a lot, Supreme Court.
Supreme Court.
Yeah, exactly. And so because of this lack of guidance, an important piece of this puzzle is that lower courts are incredibly hesitant to expand unenumerated rights. So these rights that aren't explicitly mentioned in the Constitution, lower courts really follow the Supreme Court's lead, and they won't expand those without kind of like guidance from the Supreme Court. Right. And so that's kind of a mark against the parents' position here, because they're basically asking the court to expand rights that the Supreme Court
and that aren't in the Constitution.
Yeah, that aren't in the Constitution and that the Supreme Court hasn't already recognized.
Yeah, so it seems natural that other courts would be reluctant to do that.
Right.
Yeah.
Yeah. Because they have to follow what the Supreme Court does.
Right.
Yeah.
Exactly.
And so the trial court here considers all of this, and then it does what courts usually do, and it tries to find analogous situations that other courts have dealt with dealing with similar claims. So all courts do this. They look at other case law to see like, is this case like that case?
Right.
Right. And so the court identifies two really significant cases that I want to highlight for examples of other situations that have dealt with these kind of substantive due process claims, looking at whether or not the behavior of the school official or the governmental official was egregious or conscious shocking in the constitutional sense.
Okay.
Right. So the first example involved a mother who claimed a substantive due process violation when a social worker made the decision that the mother was unfit. And so the social worker released the mother's daughter to the grandmother instead of the mother's custody.
Okay.
So social worker gave the kiddo over to grandma instead of mom. And mom brought a lawsuit and said, look, that violated my parental rights. You literally took my child away from me because of your judgment that I was unfit. And there was a lawsuit. And the court in that situation found that even that intentional and direct interference with the parent's interests was not enough to rise to the level of conscious shocking behavior.
Oh.
So even, literally
even taking somebody's child away from them.
Well, it wasn't taking it away. It was refusing to give.
Oh, okay.
So, context.
Yeah. You lawyers and your precision.
If there's one thing that, if there's one good thing about lawyers. All right. So in another example, this one was involved a school. A family claimed a substantive due process violation after a student, and this is a really tragic story, after a student was electrocuted and died during a high school science experiment involving reading voltage from live wires.
Oh, wow.
Yeah. So really tragic case, right?
Yeah.
And the parents alleged that the science teacher's deliberate indifference to the potential risks of the experiment rose to the level of egregious behavior necessary to support this 14th Amendment substantive due process claim. But the court in that case actually disagreed and didn't find a 14th Amendment violation.
Wow. So that just shows how hard it is to establish this sort of level of egregious behavior, right? But that doesn't mean in those particular cases there weren't other legal problems, right?
Exactly.
We're talking about substantive due process here, and that doesn't mean that there were not other legal violations in, for example, the case where that student was electrocuted and passed away in the course of a science experiment could be tort,
right. You could have tort liability,
negligence,
wrongful death. There's a ton of other legal claims that you could bring to remedy or to, I guess, hold the school accountable for that. Right.
Right.
And so, we are just looking at the 14th Amendment's due process clause here. So there might have been other claims here, but the parents' claim in this case is just the 14th Amendment. And so, that's kind of what we're focusing on here. But that doesn't mean that in these other cases, there weren't other remedies available for what happened, right? Just that it didn't rise to the level of a constitutional violation.
Got it.
Which just, shows how high of a bar it is to state a constitutional violation under this substantive due process standard.
Yeah. Yeah.
Mm-hmm.
Okay.
Yeah. So the court looks at these examples and, these are very severe examples, right?
Yeah.
And the court concludes that the school's conduct here of not involving the parents in AG's support plan or the development of the support plan, that conduct, according to the court, wasn't nearly as
serious,
significant, as serious or as extreme as those situations. And because those didn't rise to the level of a substantive due process violation, then neither does this.
This one can't either, right?
Right. Yeah.
Okay.
So the court's or the school's action of leaving out the parents, that, according to the court, was not egregious. It wasn't conscious shocking.
Yeah.
And so the court says that there's no 14th Amendment violation here.
Interesting. That is really, really interesting. So at the end of the day, they granted that motion, that 12B6, right?
They granted the school's 12B6 motion to dismiss.
And which basically means that in this particular case, at this point, the parents lost.
Right. Yeah. So the court dismissed their federal constitutional claims without prejudice, which basically means that they could refile them with new facts. Mm-hmm. So if they, develop more facts that kind of showed the school
did something else.
Yeah. And the court really makes a big deal about the fact that the school here was not acting maliciously. They weren't acting with an intent to harm, everything. And the court doesn't explicitly say this, but they kind of, tacitly infer or, take the position that the school was doing what they thought was in the students' best interests. And without that intent to harm or without that malicious intent to harm the parents,
mm-hmm.
then there wasn't enough here to rise to that constitutional level.
Okay.
Yeah.
So one of the big takeaways, right, is the fact that it illustrates how complicated these issues are, right? So I don't know about you, but I've been talking about a lot of this in many of my classes that I teach. What makes this so hard is that everyone, for the most part, everyone wants what's in the best interest of these kids, right? Parents, teachers, schools, even some policymakers want what's in the best interest of the kids. But oftentimes those groups don't agree on what's best actually is.
Right.
Right. And people feel very, very strongly about this issue. It's very, very personal. It's often very value laden.
Right. Yeah. I mean, it's hard to kind of come up with an issue that is more personal or more value laden than the education and the care and upbringing of children. Right.
Right.
And it raises those really complicated questions about where spheres of influence and lines of authority lie.
Right.
So this is something that we've talked about a ton. And it's something that doesn't have easy answers.
No.
Right?
And one of the reasons why it doesn't have easy answers is because the laws and the policies around these issues are not clear. And, schools don't have clear guidance from courts on how to navigate these issues. And the legal landscape around these issues is constantly changing.
Right. Yeah. So this all happened in 2020 and, the law in Florida around, restroom access, around issues of pronouns, that has changed so substantially because of the shifting legal landscape.
Right. And it's interesting in this case, if this case was to have happened now, it could be a completely different, we don't know,
Right.
but it could have a completely different outcome because the laws in Florida and everything have changed just in the last 3 or 4 years. That support plan, for example, that the district has or had
Right.
is no longer in place.
Right.
Largely because of some of the
policy,
changing
right.
policies.
Yeah.
Right.
But this is, this case is just looking at the constitutional claims,
exactly.
right? So like
right.
Those state law claims, that's another potential takeaway is like, it's so important to know your local context and your local laws and things. Cause like, just because it doesn't rise to the level of a constitutional violation doesn't mean there aren't these other things that we need to be aware of and to navigate.
Yeah. And the other rock in the hard place issue that we haven't really talked about yet is how so many of these cases are starting to reveal this sort of rock in the hard place issue that schools are in, where, one side are state laws and policies and the other side are federal protections, right? And oftentimes those are in competition with one another, right? To follow a state law means you are potentially violating a federal.
Yes. And we've seen that, especially in the Title IX context, right? And equal protection as well, which is also protected under the 14th Amendment of the Constitution.
Right.
And it just kind of shows how challenging it is for school leaders to navigate all this. But one of the other things that, I really kind of take away from this case and cases like this is just the leeway that courts will give to school leaders, either through doctrines like qualified immunity or these other things, whereas, if these schools are acting in the best interests of students, then courts are pretty hesitant to second guess those schools unless, it clearly violates these established rights or these other things. So like even
that should give you a little bit of relief.
Right. Yeah. Because there's a lot of room for discretion here. There's a lot of room for professional judgment, which is why, it's so important to know the law, but then also to know what you can do within the law or even through the law to advance your own kind of educational goals.
Exactly.
Because there's always going to be possibilities and potential there for you to do that.
Yeah. That is really interesting. This is
this was a fun case.
This was a very interesting case to look through, and I hope everybody enjoyed listening to that story and that context and how this played out. And there's going to be a lot more of these things. There already are a lot of these things out there.
Right.
And
this is an issue that we're going to have to keep watching because it's going to keep coming up.
It's going to keep coming up, which means that it will likely, in some form or fashion, make its way to the Supreme Court. Now, whether or not the Supreme Court would take this stuff up remains to be seen.
Right.
Because sometimes, they don't take things up when they've already been dealing with lots of controversial issues. And sometimes they don't take things up when it's too hard for them.
And this is one of the, this is a hard one. This is a tough nut to crack.
Yeah. So it's going to be interesting to see how this plays out.
It is.
We'll keep you posted on this one and anything else that comes up. All right. So what's our homework, Chris?
Your homework is to enjoy the rest of UCEA for those of you who are here in person. If you're not here in person, you're listening to this in January, I guess your homework is to be jealous of the beautiful weather we have here in LA.
Sunny,
depending on where
California.
you are, I guess, right?
Yeah.
But you can find Chalk and Gavel wherever you get your podcasts. We would really appreciate if you would rate, review the show. That really helps us spread the word, get the word out there and enhance our reach. You can go to chalkandgavel.com. We've got a feedback form up there. We'd love to hear from you, love to continue the conversation. You can also find our teaching guide up there if you want to assign Chalk and Gavel to your classes or for professional development, or if you just want to share it with a friend. Find us on social media at Chalk and Gavel, and we look forward to continuing the conversation.
All right. Well, that does it for this episode. So we'll see you again in 2 weeks, folks. Have a good one.